So the third maxim that we'll be interrogating today says that where the equities are equal, the law prevails. I repeat, where the equities are equal, the law prevails. I need to point out that where this maxim is usually applied is where there are competing interests, and the court wants to decide the one that should take priority. So there are two interests, the legal interest and the equitable interest. The legal interest is provided by the law and the equitable interest by the court of equity. So there are times that there are two competing interests, in the sense that there is the legal interest and there is the equitable interest. And this is what the court is saying, that the legal interest will always take priority over the equitable interest. But that is provided that the holder of the legal interest is a bona fide purchaser without notice. That is, provided that he does not know that there is an existing equitable interest. And that is why where the equities are equal. If the equities cannot be equal where you have a legal interest but you are aware, you have knowledge of an existing equitable interest. By that regard, because of the rule relating to notice, the equities are not equal. So you cannot say your legal interest will take priority over the equitable interest. But where the equities are equal, then the legal interest always takes priority over the equitable interest. So take, for example, in a trust, we already know that the trustee has the legal interest and the beneficiary has an equitable interest. So supposing the beneficiary tries to alienate the trust property and sell, the beneficiary is having an equitable interest. So which means that the only interest the beneficiary can transfer to another person must be an equitable interest. Now the receiver of that equitable interest, the interest will now be an equitable interest, and that interest cannot take priority over the interest of the trustee, because the trustee has a legal interest and the equities are equal. Are you following? The equities are equal. And take another example. If it were to be the trustee that tries to alienate, it means that the trustee can pass a legal interest. The legal interest it has, if you should pass it to another person, that person will acquire the legal interest. And if the person did not know that it was a trust property, so which means the person would not know that, oh, there is a beneficiary that has an existing equitable interest. Now what we are saying is that yes, there is the beneficiary with an equitable interest, but the beneficiary's interest cannot take priority over that of the legal interest of this third party, because the third party has acquired the legal interest from the trustee and he was not aware, he didn't have notice of the existing beneficiary equitable interest of the beneficiary. So he's a bona fide purchaser without notice. So you can see these two cases. Now you see the case of Pitcher versus Rollins. So in Pitcher and Rollins, X, who was the sole surviving trustee of a trust fund for the benefit of A for life, and after his death for A's children, he lent money to R, that is the trustee, lent money to R, and R fraudulently, by omitting the mortgage to X in the abstract of title, so that the fee simple apparently remained in R, conveyed the legal estate to B by way of mortgage. So he lent the money to R. R, did some fraudulent activities to make it look as if he was the owner of that particular fund. And R now conveyed the legal estate to B by way of mortgage, the mortgage property to another person. The question for determination was whether A or B had priority over the land. You remember that A was the trustee that basically borrowed R the money. Now R had already mortgaged the property, so to say, to B. B has acquired an interest. Then A also has an interest. Now what did the court decide? The court held inter alia that as B had acted honestly and reasonably, and as he had no notice of earlier mortgage transaction, he was entitled to priority over A, whose interest was equitable only. So you can see, because X was the trustee, A was the beneficiary. So what the court was saying, that B's interest will take priority over that of the beneficiary, that is A, because B had acquired the legal interest and he didn't know that it was a trust property, so he had no notice. Another case is the case of Joseph versus Lyons. In Joseph and Lyons, A assigned for valuable consideration is after acquired stock in trade to the plaintiff, then subject to a proviso for redemption. Then before the plaintiff took possession of the after acquired stock, A pledged part of it with the defendants who had no notice of the assignment. The court held that the plaintiff's interest in the after acquired stock in trade was equitable, and that since the defendant's interest was legal, and since he had no notice of the plaintiff's earlier equitable interest, he had priority over the plaintiff. So you can see what we mean when we say that where the equities are equal, the law prevails. Simply saying that legal interest will take priority over equitable interest, provided that the holder of the legal interest does not have notice of the existing equitable interest. And that is that for today. Now, next